This courtroom moment starts with doubt, and it only gets worse from there. A 38-year-old woman, struggling with addiction and health issues, is standing before a judge who clearly isn't convinced she deserves probation. But as the questioning begins, contradictions start to pile up. Claims of casual use, strange encounters, and a story that just doesn't add up. Add to that 2 children at home, including a minor with no adult supervision, and the stakes instantly skyrocket. This isn't just about drugs anymore. It's about responsibility, honesty, and whether the court can trust her at all. The real question is, can she turn things around, or has the damage already been done?
About 8 years ago.
Doing what?
Disabled, Judge.
Yeah.
All right. What's your disability?
I have seizures and nerve damage on my right leg.
How often are you using meth and heroin?
That,
Okay, let's not do that because you're here for meth and heroin. So how often have you been using meth and heroin before you went to the jail?
Heroin, I don't use. Meth, I would use it like here and there.
This is not a hearing.
This is where the judge zeroes in, and the tone shifts dramatically. The defendant tries to downplay her meth use, calling it here and there, but the judge isn't buying it. Why? Because a police report tells a completely different story. And in court, credibility is everything. When your statements don't match the evidence, it raises serious red flags. The judge even challenges her logic, pointing out how unlikely it is for a sober adult to randomly accept rides from strangers involved with drugs. This isn't just questioning, it's dismantling the narrative. And now the bigger issue emerges. Is she being honest, or just saying what she thinks will help her avoid prison?
Were you using meth?
Grandma day.
So why were you just not honest with me about that? Why are you pretending like you don't have a drug problem? Everybody on this planet has something that they're working through. We all hoped that whatever is not what we want it to be in our life, that we're working to improve that and improve who we are. I mean, you've already pled to a drug case. I've read the police report. So you're not sober, you're using drugs. And in order to become sober, you're going to have to admit that you first have been using drugs and that you have a problem. Otherwise, I can't help you. Otherwise, maybe you should just go to prison. So you just want to go to prison and do your time?
No, Judge, I think she might have been confused. There was quite a bit of time from the arrest that she was out on bond until today, and her rearrest on the FTA.
I don't think she was confused. I think she is trying to pretend like she doesn't have a drug problem, but it's obvious you do. So we're going to take care of it if you want it taken care of.
She does.
So, counsel, has there been anything that she's done to support her habit that would make her a better candidate for Esperanza Court? Because felony drug court, they have a waiting list.
I'm not aware of anything.
You want to ask her?
Recently.
In the past is fine. If it's something she's done in the past, that's good.
I know we spoke to pretrial about potential. She talked to pretrial about potential just substance abuse treatment and stuff.
Well, what I'm saying is there's a certain requirements for Esperanza Court. Do you want to speak to her and see if she meets the requirements of Esperanza Court?
At this time, I'm not aware of any, Judge.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated in prison. Suspended and probated for 5 years. There's $1,000 fine, probated. There's going to be a referral to felony drug court. That'll be the first referral. Then it will be Esperanza Court. That will be the second referral. I'm going to want a TAP evaluation while in custody.
Here comes a critical decision, and it's not what the defense was hoping for. Even though probation is granted, the judge orders a custody-based evaluation, meaning she won't be released in time for the holidays. Why? Because the court believes she's still at high risk of using again. This is a key legal point. When a judge doubts a defendant's honesty or stability, they can impose stricter conditions, even within probation. The defense argues a compassion, emphasizing family time and the holidays, but the judge prioritizes safety over sentiment. And honestly, it raises a tough question. Should emotional factors like holidays influence legal decisions, or should the court stay strictly focused on risk and accountability?
Use. And here's the thing, be it heroin, be it meth, that could be the last time she uses.
The drug test every single day I will.
No. So that'll be top evaluation while in custody, follow the, all right, good luck to you. We can go off the record. I know you want to be out for the holidays. Everybody wants to be out for the holidays. But this is what I can tell you. You're trying to set up your future, right? And your children, 17 and 22, you can always celebrate the holidays after the holidays.
I want to be with my daughter. She's 17.
I mean, I think she knows about Santa Claus and everything. And she knows what Christmas is about.
I'm not that they have.
Yeah. Well, here's the thing. If you're all that your 17-year-old and 22-year-old have, you shouldn't be using meth. And you shouldn't be using meth because, number one, it's not the right thing to do, and your children are depending on you. And number two, you have health issues where you shouldn't be using meth. And let me ask you this question. If you hired me as a babysitter for your 17-year-old and 22-year-old, just to be there, because sometimes you want an adult in the house, right? To look after them, to make sure everything goes well, right? And let's say your attorney recommends me to do that, and you check all of my references, they're great. And your children say, yeah, we like Stephanie. Let her come by whenever you can't be here to make sure everything is running well. And you decide to hire me. And as I'm leaving, I tell you, I probably should let you know, I do a gram of meth a day. Would you still want me looking after your 17 and 22-year-old?
No.
That's the position you're in. You are that babysitter who's doing great with the children. And then I'm going to hire you. And then you turn around and tell me I've been using a gram of meth a day. That's not good for your children. You understand?
Yes.
And honestly, I don't know what would happen if I would release you. You may end up using, and that may end up being a bad batch, and you may end up overdosing. Then what kind of holiday would that be for your children? Okay. All right. Good luck to you.
Judge, I just want to ask one more time if you'll reconsider. I just think that there was confusion with the time of the offense versus today, which has been quite a bit of time. To be successful on this probation and to trust in the process, I think that giving her the time out and allowing her to decide to do well and show this court that she can do well, and she's willing to do daily UAs. I don't think she was trying to be dishonest with this court at all. I do think she just didn't understand and the difference between then and now. If there's just anything the court can consider, any conditions, she'd be happy to meet to be able to spend the holidays with her
All
family.
right. Thank you. And I appreciate the argument that you've given, counsel, but my ruling stands. Good luck with you. Are you the same Valerie Lorraine Martinez who's placed on community supervision in 2022, CR 5304, for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on December 20th, 2022, for a term of 5 years? Is that you?
Yes.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Valerie Lorraine Martinez, did then and there fail to report to the supervision officer as directed for the months of December 2023 and January 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And Your Honor, we waived the other violation alleged in the motion.
Any objection?
No.
Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation. I believe the defense would like to be heard.
All right, defense.
Judge, Ms. Martinez, the court has given her many opportunities that she's had a couple of different things in the Esperanza court. Then she was medically ineligible for one of the treatment programs. That the treatment programs just have not worked out for her. She's actually asking the court to be placed just on regular probation and to let her go forward. She's actually got 200 days credit from all these different times that she's been in and out of jail and waiting for beds and waiting for treatment facilities. So she'd just like to be placed on regular probation and go forth in that way.
All right. Any objection to the court reviewing the court summary from probation?
No, ma'am.
No,
Hank has that.
okay.
Thank you. Oh, I have it.
Okay.
All right. So they state in the court summary that you were given several opportunities for treatment and to get back into compliance, because I know with the treatment courts, if you abscond and they get you back with a certain time frame, they still want to work with you. They said they tried outpatient treatment with you, sober living with you, all of the Esperanza court resources. There's nothing else that can be done for you. And if you could not follow through that program, there's no reason for me to believe that you would follow through on probation. You'll still have the same problems. It appears that you've just been running from your problems, running from treatment and continuing to use drugs. So I don't believe probation, that you're a good candidate for probation. Everything has been tried with you.
I've been cooperating and I have been clean. Your Honor.
No, according to this, Esperanza Court removed you from their program. I know, and I'm not taking into consideration, but
I
you absconded.
satisfied 3 months outpatient rehab. I did complete the remote recovery in motion program. I got my certificate.
All right. So here's the thing. If we could all write our own program, we wouldn't be here. If you could write your own program to remain clean and sober, guess what? You wouldn't be on probation for possession 1 to 4 grams. If you could write your own program to be clean and sober, guess what? You never would have tested positive while you're on probation. You can't write your own program, and that's what you're trying to do. I'm going to grant the motion. All right, with regards to time, state, what are you requesting, and defense, what are you requesting?
We're looking to 4 years.
State?
Judge, we'd ask for the minimum. She has been in and out of these different programs. She has at least attempted to comply on multiple occasions. So we would ask for the minimum.
All right, has she paid the $114 restitution? Did you pay the restitution of $114?
I did make payments, ma'am. Yes, ma'am.
Okay. All right, has she successfully completed any inpatient treatment?
So it looks like she was disqualified from DDRF. She was medically ineligible. Then the felony drug court, she was referred to the Esperanza court. And then the Esperanza court is when we started to have some problems.
All right, this is what the court is going to do. The court is going to revoke you. The court will sentence you to 4 years in the prison, give you credit for any time served. There's a $1,000 fine. Time and money will run concurrent. And I'll recommend the therapeutic community for you. I can recommend it, but you will have to ask for it, because I have no jurisdiction to force them to place you in the therapeutic community. Everyone's dry. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it, and did you sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. You're going to have to stop using.
This case delivers a powerful and sobering outcome. After multiple opportunities, failed treatments, and continued noncompliance, the court ultimately revokes probation and sentences a defendant to 4 years in prison. The judge makes it clear this decision isn't about one mistake, but a consistent pattern of avoiding responsibility and failing to follow structured treatment programs. Even so, there's still a path forward, with a recommendation for therapeutic community treatment to address her addiction. The bigger takeaway: The system can offer chances, but it cannot force change. That has to come from the individual. So what do you think? Did the court make the right call, or should there have been one last opportunity for recovery? If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.